Thank you for clicking this video. This is Batok with Ola. My name is Mojola Oluwa, and today we want to talk about how to substitute emotion before the court. That is how to withdraw emotion and substitute emotion. Essentially, I want to talk about if you have made an innocent mistake on a process or emotion that you filed before the court. And I'm saying this so that you do not, use a sledgehammer to kill an ant necessarily, to make this easy. So what do you do, for instance, if you made a typographical error? Say maybe you were supposed to write motion for extension of time, and you have now written, motion for substitution of charges, I'm just giving examples. Maybe you're supposed to write one thing and you've written another thing. These things can happen because, at law firms, in many law firms in Nigeria, I've been at a few, so I should know. Many law firms in Nigeria will use templates. That is, when we've already prepared a motion, or some, we've prepared some processes already or before. When we want to prepare a similar process, we just go there, we edit it, then we impute the new information and leave the old ones that still apply to what we are about to prepare afresh. So it could be that you're using a template for an old process for a new one. Maybe now you have put the wrong name of the defendant or the claimant when it should be another name, or you have put the wrong title, or maybe you even gave it to a typist to type for you and they've typed something wrong or made a mistake, and you did not avert your mind to it before you filed it in court and served the other party. All you need to do, if you discover in time or on time, is to, if you discover soon enough, all you need to do is print another one, prepare another one, go to the registry, ask them if they transferred it to the court file. If not, then you replace it. If thankfully it is not the page on which the registrar's endorsement is for filing, you can just remove it and put the new one, the correct one, and then you get across if they've served it already, or if you undertook personal service and you've given it to the other counsel, just reach out to them and replace it. That if it's not the endorsement page. But if it's an endorsement page, you might need to get them to endorse it for you afresh. Since it's the same thing, it's just a mistake. If it's same day, for instance, you don't have to pay another fee. You just re-endorse it for you. Then they take that old copy, you put the new copy, and then you are home and dry. Essentially, you just need to have the correct copy in the court file and in the other counsel's file. And if, for instance, they say that they've transferred it to the court, all you need to do is go to that court and talk to the registrars. If they would let you, then you just replace it, as I have said. Now, what if the matter is coming up that day and you have just discovered and they would not let you access, they would not let you just swiftly change it like that? When the matter is called, you can simply inform the court that there's a typo or an innocent mistake that does not fundamentally change the course of the matter or the content of the process, that does not give a different flavor, that any reasonable person will look at it and say that, oh, this is a mistake, or this does not create a different impression in the mind of the judge or the mind of whoever is reading it, or in the mind of the other counsel. So then you tell the court that you have brought the correct process and you would like to substitute it. So you apply to withdraw the old one and substitute it with a new one. You don't need to file a motion for this if it's a very simple error or mistake. In fact, in some courts, the judge might even ask you to approach the bench or approach the registrars. They pass the process to the registrars and ask you to replace, or to even write it with a black pen, depending on how grand the mistake is or the typo is. So if it's something you can correct with a pen, a judge might even ask you to come forward and correct it, or ask the registrars to pass it to you, the court copy. Now you correct it and you pass it to the court back, and then you can do that for the opposing counsel too. But in any case, if that's not possible, then you can ask the court to allow you to substitute the process. But the court must have an endorsed copy that has the registry's endorsement that you have paid and you have served. But if it's a grave mistake, if it's something that cannot be overlooked, that fundamentally affects, the course of the matter, you might need to apply to court for an order of amendment In some cases, you could even bring a deeming order. I've done a video on deeming orders. Please watch it. But in some other instances, you might first ask. You might first have to ask, especially if the rules of court of that particular jurisdiction do not provide for a deeming order. You might have to ask the court for an order granting you leave to amend, and then you would amend and file new processes, and then you come to court on the next adjourned day to substitute. So you first apply to withdraw the old one and substitute it with a new one. Make sure that at any point in time when you are withdrawing an old process before the court, you are substituting it with a new one, because leaving it vacant can be very dangerous. There was a day we were in court, and our senior, we had filed amended a process, and our senior was withdrawing the old one before the court, substituting with the new one, and then it turned out that the new one also had another error, and senior wanted to withdraw it. Thank goodness that something happened, and we were able to signal to each other, and senior was able to realize that they're not supposed to withdraw it, and they left it. Because if they had withdrawn that new process, that would mean that because the court, we had withdrawn the first one and the court had struck it out, admitted it as withdrawn, and we had brought in the new one, and now we were trying to withdraw the new one because of the newly discovered error. That would mean that there's no process before the court, and the other party would have gone home free. In fact, when senior sat down, and we're all the other counsel, the other people on the other side, the lawyers on the other side, were telling her that they were waiting for her to finish withdrawing and sit down so that they can tell the court that there's now no more process before the court. I'm talking about an originating process now. You cannot leave it blank. So, and then they would have told the court to let their clients go free, because now there's no process before the courts to which their clients is answering anymore. And this was a case that stage had spent about 3 or 4 years in court. So you can imagine, be very careful. If you're withdrawing a very important process, especially an originating process, make sure you're substituting it right away with a new one. So that's how to correct a mistake, an innocuous, simple mistake before the court on any of your processes, especially if there's no provision for you to bring an amendment, application for amendment, or to ask for an order of amendment. If there's no particular provision in the rules of court for you to ask for an order or leave to amend, you can just do it the way that I've explained. That's all I have for you in this video. I'll see you in my very next video. Don't forget to subscribe. Toodles.